It's been nearly a month since we last saw Luigi Mangione in court, the man accused of stalking, shooting, and ultimately killing UnitedHealthcare CEO Brian Thompson. Mangione has pleaded not guilty to all charges. Now, as he sits behind bars awaiting trial, he's making a bold request. The 26-year-old wants access to a special laptop. His attorneys argue it's not for entertainment or communication, but to review evidence. Thousands of pages of legal documents prepared by the prosecution. But the Manhattan District Attorney's Office is pushing back. I'll walk you through the details. For Law and Crime News, I'm Kennedi Walker. Luigi Mangione's legal team is gearing up for what is expected to be a highly publicized trial. The 26-year-old has been indicted on 11 state charges and faces 4 federal charges, including first-degree murder, murder in furtherance of terrorism, criminal possession of a weapon, and stalking. Mangione has pleaded not guilty to all counts. Now his attorneys are making a controversial request. They want Mangione to have access to a laptop while behind bars. Their reasoning is the large amount of discovery evidence prosecutors are expected to provide. In a recent filing in New York State Supreme Court, Mangione's defense team, Karen Agnifilo, Mark Agnifilo, and Jacob Kaplan, revealed that discovery includes more than 15,000 pages of documents, thousands of hours of video, and other critical material. They argue without a laptop, there simply aren't enough visiting hours for Mangione to properly review his case with them. The laptop, however, would come with strict limitations. It would be unable to connect to the internet, run video games, or other entertainment. Requests like this are not unheard of. In fact, similar accommodations have been made for other high-profile defendants in the federal facility where Mangione is being held, including music mogul Sean Combs, known as Diddy. After being denied bail for the 3rd time, Combs was granted access to a laptop in December to prepare for his legal defense against sex trafficking charges. But in Mangione's case, prosecutors are fighting back. The district attorney's office is opposing the request, citing concerns over witness intimidation. They claim some witnesses in the case have already been threatened, though Mangione's lawyers insist he has no connection to those alleged threats and that the claims should not be taken seriously. With a high-stakes trial looming, the battle over this laptop request is just one of many legal fights still to come. Luigi Mangione has already made headlines for his high-profile legal battle, but last month it was his wardrobe that caused controversy in the courtroom. Mangione was granted special accommodations for what his legal team described as his fashion needs. Before a court appearance, he was allowed to change out of his jail-issued clothing, a privilege rarely extended to defendants. But prosecutors say he violated that special treatment when handwritten notes were concealed inside of a pair of socks he was permitted to wear. According to a recent filing, there were 2 personal heart-shaped notes, one addressed to an unknown person named Joan, and the other written to Mangione himself. That note in part read, quote, "Know there are thousands of people wishing you luck." Despite the notes being discovered, prosecutors say Mangione was still allowed to wear the socks he had chosen, but later he changed out of them, allegedly because he felt they did not look good. Meanwhile, support for Mangione has not slowed. A defense fund already raised more than $760,000 and is now pushing to reach $1 million. And joining me to talk more about this is legal expert Serena Townsend. Serena, thank you for coming on. Let's dive right in. So Luigi Mangione's lawyers argue that without a laptop, he cannot effectively review discovery evidence. Do they have a strong legal argument here?
They absolutely do. First of all, it is not uncommon for detainees to have laptops in federal custody to be able to review their evidence. Second of all, the amount of evidence, the volume of evidence that has to be reviewed is probably bigger than most people's discovery or evidence in their cases. And they're not wrong. Karen Agnifilo, his attorney, is not wrong to say that it's pretty much impossible for Luigi to participate in his own defense, which is a right that he has, without his ability to really concentrate and focus on the evidence that the prosecution has against him.
So how common is this when people are requesting laptops? Does it seem like most inmates are requesting laptops for their evidence?
Not that common, and particularly it's not that common in state cases. So Luigi is in a very particular situation where he's locked up in federal custody because he's got the federal case pending. But this particular argument was with the state and the state's case. Now, the feds have said that they have no problem with Luigi having a laptop. And that's probably because it's a little bit more common in federal cases where there may be more evidence or more discovery to go through for them to allow those laptops into federal custody. But the state, the Manhattan DA's office is simply refusing to allow him access to that laptop. And I think it's because they just don't see those requests as often. And they're claiming that it's dangerous for him to have that laptop.
Yeah, speaking of that, like how you said, the prosecution, they strongly oppose this request, citing witness threats. How much weight does this argument hold?
I think it holds very little weight. I think they're being histrionic. I think they're exaggerating the potential for danger here. There are cases where a defendant is not supposed to be able to see their evidence because a judge allows that protective order. A judge says, okay, this person has been violent in the past to potential witnesses. We've seen evidence that he's currently being witness tampering and threatening witnesses. There is no evidence whatsoever that Luigi has or intends to threaten any witnesses. So I do not think that their argument holds water at all. I understand, I think, why they're pursuing this argument. They're saying that, there's so much interest in this case. Maybe people may act on Luigi's behalf to be intimidating. He's got a lot of supporters, but that's not his fault. And he is the defendant and he has rights in this case. He has the right to prepare proper defense in this case.
Could denying Luigi access to a laptop create grounds for an appeal if he is convicted?
Absolutely. Any rights that are being trampled on is grounds for some sort of appeal if he is convicted. And that's why it's so important for his lawyers to continuously object to the trampling of these rights, which they are doing, and to make a note of it and to put it on the record. Because if they don't do that, then a lot of times Luigi will lose his right to appeal on this issue. Even this delay, I would argue is causing, a disadvantage, an illegal disadvantage to Luigi.
Will the judge step in cases like this, or do just both sides kind of battle it out?
Absolutely, the judge will come up with a decision. What'll happen is the prosecution will have to respond to Karen Agnifalo's motion, and it all comes down to the judge in the end. The judge will issue a decision. If the judge needs a hearing on it, then he'll, order a hearing. But usually, a judge will decide something like this on the papers alone.
And like how you said, this is more common with federal cases. We know in federal cases, other defendants like Sean Diddy Combs have been granted laptop access. Could Mangione's team use this as precedent?
Definitely. You always want to be able to show examples of hypocrisy and examples where things favor your client. And that is a great example that Sean Diddy Combs, who I don't even think it's arguable, he definitely has more influence than Luigi Mangione with the amount of money he has, the amount of connections he has, and frankly, the charges that he's being charged with. I'm pretty sure they shed light on his potential to influence or tamper with a witness way more than somebody like Luigi Mangione. So I do think that bringing up Sean Diddy Combs and maybe other people who have access to the laptop is a great way to show that this argument should not be sustained.
Are there any risks of tampering or unauthorized communication if he's given a laptop, even with restrictions?
Um, of course, there's a risk that somebody would be able to mess with the laptop, but for the most part, those laptops are stripped of the ability to communicate. They're stripped of their internet access and software, and basically, it's just a bare bones machine that allows you to view evidence. I mean, in my opinion, I almost don't think that they're worried he's going to use the laptop to commit the witness tampering. It feels like they just don't want him to see certain pieces of evidence and then be able to communicate maybe in other ways, whether through a letter or through the phone to witness tamper. But again, I don't see how they can show any proclivity for him to do this or any evidence that he desires to do any of this.
If this request is denied, what alternative options does Luigi have to review the 15,000 plus pages of discovery?
Well, I would yeah, I mean, I would make an argument, although it's a losing argument, and say, "Well, judge, if he can't review it on the inside, you gotta let him out and let me review it with him in my office," right? That's where I would go first with it because you're not giving him a reasonable alternative. There's only so many hours that Karen Agnifilo or her team could actually physically visit him and show him the discovery. Plus, you and I and everybody knows that it's a very different situation when you're literally sitting there with your lawyer and they have to like flip through things and show things to you. You want to be able to sit there in the long hours of the night and review things on your own over and over and over again because this is your life. I mean, he's facing the death penalty. So, you can't mess around with that. So the other opportunities are really, they're not favorable to him and they don't really allow him the rights that he is owed. Having Karen go there and just sift through this stuff with him here and there is just not going to cut it.
Could Mangione's request for a laptop be seen as an attempt to prolong the trial or delay the proceedings? Do you think that's what the prosecution could be arguing?
They could be, but I don't think that holds water simply because, in my opinion, if you're forcing Karen Agnifilo and her team to just piecemeal come to the jail and show you things here and there for a couple of hours, that's going to delay things way more than having him, just have the discovery at his disposal and let him prepare, from A to Z in his time.
Given the severity of these charges that Luigi is facing, could evidence suppression or pretrial motions play a major role in the defense's strategy?
Absolutely. So it's very important, and I think a lot of people are now going to really understand because they're following this process so closely, the general public. Part of winning a case is not just at trial. It's all of the steps that lead up to the trial. It is a defense attorney's job to constantly chip at the evidence and the proof that the prosecution claims to have and to be able to suppress or get a judge really to suppress, to agree to suppress certain pieces of evidence that the prosecutors want to use that the defense could claim should not be used, whether because it was prejudicial or it was recovered illegally by police. There's numerous ways that they could chip at that, and they should. And I do think that they will do everything that they can to try to, narrow down what a jury will be able to see at trial.
The case involves alleged terrorism charges. What evidence would the prosecution need to prove these charges, and how difficult would that be?
It is difficult, and I actually think that the prosecution has severely overcharged this case. I think they wanted a murder in the first degree charge to stick, and so they threw it out there. But all you really need for murder in the second degree, which is the lesser charge, is that he intended to kill this person. And even that, that is what fits this crime if he, in fact, is the one who did it. In order to prove, the terrorism charge, they're going to have to get pretty fancy. I mean, how are you going to prove that his motivation and the object of everything was to terrorize a community? What community people was he terrorizing? Were they in fact terrorized? Did he have the capacity to do that? I mean, compare that to like a 9/11. I mean, that's terrorism. Can you really say that that's what Luigi Mangione or whoever shot this person did? I think it's a stretch, and prosecutors typically do this. They overcharge because it allows them to compromise. It allows them to get a plea bargain or to have a jury give them the verdict that they actually want, which is the murder in the second degree.
And just going back to the laptop dilemma, if
Yeah.
Mangione were granted the laptop, would it be unusual for the court to put restrictions on how much time he can spend reviewing evidence each day, or is it kind of like a free for all?
I don't think that a judge would actually step in and say, you can only review it for X amount of time. Typically, in the jail setting, you have to just follow the rules of the jail. And a judge typically doesn't deal with that. I mean, sometimes a judge, orders the jail to do this or that, orders them to produce a person to the courthouse, orders them to allow that person to seek medical treatment, things like that. But other than that, the operations and the security of the jail is typically left to the jailers. And so if there's like a lights out or, times where he's not able to view the discovery because those are the jail rules, it'll typically go by that rather than a judge.
And we know that Luigi is facing both state and federal charges. What exactly does that mean in terms of potential sentencing?
That's a great question. I mean, it looks like the state is going to be moving forward first. And so, they purposely don't move in a parallel situation because one is going to affect the other. It's possible that after he goes to trial on the state case, the result of that case will have an impact on how the feds go forward or don't go forward on his case. So sentencing is going to be very interesting because if he's found guilty of one and not the other, or what if he's found guilty of both? Maybe the judge would run those sentences concurrently, meaning at the same time. There is a possibility for some creativity there. And so that is a whole world that we're going to have to see as this thing progresses.
Could we potentially see a plea deal in this case, or is it likely going to go to trial?
Another great question. I think in this scenario, I mean, unless Luigi really wants to take something, it does feel, at least at this point, like it's headed to trial. And again, that's going to depend on whether the prosecutors make an offer that is, palatable to him. They may just say, we're not making you an offer. You're going to have to plead guilty and then be at the mercy of the judge to determine what your sentence is going to be. And that is a scary place to be as a defendant. So, if the prosecution is not motivated to give him a good deal, he may not, want to take that plea. All of that's going to become more and more relevant after, all of the discovery is turned over and Karen Agnifilo and her team could really evaluate the strengths and weaknesses of the case.
If convicted, could he be sentenced to life without parole, or would the death penalty most likely be on the table?
The death penalty might be on the table through the federal prosecution, not the state prosecution, simply because New York does not have the death penalty. Um, and again, he's open to having that on the table. We don't know if it's going to be there yet. There's processes in place because it's such a severe punishment. And frankly, even if he is given the death penalty, the opportunity to appeal is there for him too, and that usually delays matters for years. So I don't think this story ends unless it ends in an acquittal. If he's convicted, I don't think this story ends for a long time because I think he has grounds for appeal on many levels.
And the grounds for appeal, are you just talking about the laptop or other grounds as well?
Yeah, other grounds. And by the way, those are going to become more and more apparent. There's going to always be more grounds for appeals developing as the case goes, particularly at trial. But I'm referring not just to the laptop, but to the fact that Mayor Adams is going on this perp walk with 700 law enforcement officers trailing behind him, right? Like he's Hannibal Lecter. So that was extraordinarily prejudicial to the case and definitely influenced in a bad way the jury pool, tampered with that jury pool. So there's a bunch of things that plus the documentary that's been coming out. There's a lot of prejudice that has been coming out from law enforcement, from our city leaders, if you want to call them that, and the prosecution. So I do think that there's already grounds for appeal and that there will be more coming.
Yeah, and we know that the mayor is featured in one of those documentaries that's coming out on Luigi Mangione. And so when we say, okay, there's grounds for appeal, for those that don't know, what exactly does that mean? Does that mean that, oh, because of this, that means that the case can just get thrown out? Explain that to us.
Sure. So that will only come into play if he does get convicted. Obviously, there's nothing to appeal if he gets acquitted. But post conviction, you have many opportunities to appeal that conviction on so many different grounds, whether it's because of things that happened like this pre-trial, or whether a judge made a bad decision during trial, whether you had ineffective assistance of counsel. There's a ton of ways to appeal your conviction. It does not mean that the case is going to get overturned or even dismissed. But sometimes, if you do have a successful appeal, the case will be kicked back and it will be tried again, prosecuted again. That would not constitute double jeopardy because it's different. If you appeal it, then they can in fact prosecute you again.
Now, moving on to one of the latest complaints from the prosecution, they're saying that Mangione was given special accommodations to change out of his jail uniform for court. Is that unusual?
I will say, in my experience, yes. Typically, when you do have people detained and they come to court on just regular court appearances, they are in their jail garb and they are typically not allowed, not that they're not allowed, but they're not given the opportunity to wear regular clothes until a trial. And that's because you don't want a jury prejudiced by seeing this person in jail garb, right? And if you see them in jail clothes, something in your mind is going to be like, well, he's probably guilty, or at least taint your mindset against him. But here, I don't think that it's special treatment. It is different treatment, but I don't think he's being treated specially or better. And the reason why is because all of his appearances are being televised and people are very interested in what's going on. And so this argument that you don't want to show the jury or the potential jurors somebody in jail garb, it extends to him now because unlike most defendants, he is being watched by the people who will ultimately be his jurors. So I do think he's getting different treatment, but there is a reason why he's getting different treatment, and I don't think it's fair for the prosecution to claim that he's being treated better or unfairly in that way.
And the prosecution is claiming that there were notes found inside of his socks. And one of the notes found in Luigi's socks apparently mentioned thousands of people wishing him luck. Does public support ever play a role in a legal defense?
Well, I do think it helps the psyche of the person who's being accused. They are behind bars. They don't really get to see people or talk to, their loved ones. And it's very difficult to live through that process as you're awaiting your trial. It doesn't really play a role necessarily in the courtroom, except that obviously, there's plenty of defendants out there who go to trial and you don't see anybody really sitting in the pews. Us attorneys will be there. We'll be like waiting for our cases to be called. But a lot of times sadly, you don't see many people supporting them. And I do think that there is influence on a jury when they take a look out there and they see that there's a lot of people watching this person and supporting them. Every little thing counts when you're in front of a jury. The psychology behind it is fascinating, and the public support certainly plays a role there.
What do you expect to be the biggest legal battle ahead in this trial?
Wow, I think both sides have issues, right? I think the prosecution in both the federal and state cases are going to have trouble proving the top count of the charge. I think identity is an issue with respect to Luigi, whether he's the one who actually did this or not. Depending on what their evidence shows, though, they may, we don't know exactly what they have. We don't know how great the surveillance videos are. We don't know what statements he may or may not have made. So we don't really know all of the evidence. But even assuming that they're able to prove that he is the one who did this, I still think the prosecution has issues proving their top count on the state case, which is the terrorism count. And I think the feds have a problem proving all of their counts because they have to prove, in order for it to be a federal case, not only that he committed this murder, and that he crossed state lines, which, okay, you could check those boxes maybe, but that he was also stalking Brian Thompson. And that is a difficult prong to prove because there's very specific elements of a stalking crime that you'd have to prove in order to find. So I think the prosecution on both cases has an uphill battle on those counts. And then, of course, I think, the defense is always going to have an uphill battle when it comes to a serious crime of murder, because a jury is oftentimes inclined to convict when somebody is dead. I mean, when you actually take somebody's life, they want to hold somebody accountable. And so it is difficult on that front. But both sides really have their work cut out for them.
For sure. And this is something that we will be following closely. It seems like more information comes daily. So thank you so much for joining us today.
Thanks so much for having me. I appreciate you.
The next hearing is in federal court on April 18th. For Law and Crime, I'm Kennedi Walker.